Third, the instant appeal has been preferred against the judgment and award dated 19 September 2015, passed by the learned Judge, Motor Accident Claims Tribunal, Additional District Judge, Fast Track Second Court, Bardhaman, in MAC case number 76 of 2013. Para. The brief facts of the case is that the present appellants, being the claimants, have preferred an application before the learned tribunal under section 166 of the MB Act for getting compensation on the ground that their predecessor was died in a road traffic accident due to rash and negligent driving of the driver of the offending vehicle duly insured under the policy of the insurance company. The claim case was contested by the owner of the offending vehicle by claiming written statement. Subsequently, he did not contest the matter further. The insurance company also contested the matter of filing written statement. Para. After hearing the parties and after receiving the evidence, the learned tribunal has dismissed the claim case only on the ground that the alleged offending vehicle was not involved in the alleged accident. Para. Being aggrieved by and dissatisfied with the said order of dismissal, the present appeal have been preferred by the claimants. Para. Had the learned advocates perused the observation of the learned tribunal in the impugned judgment. Para. The fact of the case in a nutshell is that the deceased was proceeding to Akui on bicycle on 11/4/2013 from Bounchadi, and when the deceased reached at Ghatirpara, then all on a sudden one tractor bearing number WP41D6570, which was coming from his back side, dashed him, and as a result victim received serious bodily injuries and was shifted to the nearest nursing home, but he succumbed to his injuries on 12/4/2013. The owner of the offending vehicle as well as the insurance company has filed separate written statement alleging inter alia that the tractor being number WB41D6570 was not involved in the alleged accident. During trial, two witnesses were adduced on behalf of the prosecution and two witnesses were appeared on behalf of the insurance company. Para. The learned tribunal, after considering the all materials and evidences, has dismissed the claim application on the ground that the vehicle bearing number WB41D6570 was not involved in the alleged accident on the grounds that Para. FIR lodged after 3 days of accident. PW1 had no personal knowledge of the accident, or PW1 has not properly stated the fact of the accident to the scribe of FIR, and the evidence of PW2 is not believed as the description of the accident by PW2 and number plate of the offending vehicle as well as the number of offending vehicle was not properly stated by him. PW2 had his acquaintance of the family members of the deceased, so he is interested witness. Para. The charge sheet does not contain the name of the PW2 as an eyewitness. Postmortem report does not suggest the death of the deceased was caused by RTA. The petitioner PW2, scribe of the FIR, and the owner of the vehicle are residents of the same village, so their evidences cannot be believed. Para. The fact does not show that the accident happened on 11/04/2023 and the victim died in the nursing home on 12/04/2013. The police case was registered on 14/4/2013 on the basis of the written complaint of widow, there are only 2 days delays in preparing the instant FIR by the widow of the deceased after demise of victim. The widow must have engaged in the last ritual, so the delay of 2 days appears to me not unjust in the facts and circumstances of this case. The observation of the learned tribunal regarding delay of FIR appears to me unjust. Moreover, the delay has been properly explained in the last paragraph of FIR. The FIR also contained the UD case, which was initially registered just after the said accident. Accordingly, the point of delay in holding the FIR as observed by the learned tribunal is erroneous. It is true that the de facto complainant is the widow of the deceased who was not present at the time of the accident. It was not possible for the widow to be present at the time of the accident, but he first got the knowledge of such accident as some person informed him that her husband was admitted to the Lifeline nursing home. She could not state the name of the persons. That does not mean the entire fact of the accident and the death of her husband is a misstatement. How the informed the fact of the accident to the scribe is only can be questioned if there is any discrepancy to the fact of the accident in this case. Moreover, FIR should not be in nature be an encyclopedia of the offense. The deceased, that is the husband of the PW1, died in a road traffic accident on the basis of which the specific police case was registered. So the doubt of the learned tribunal regarding the manner of the accident stated by the PW1 to the scribe appears to me not justified. The Honorable Supreme Court in Amita Sharma and others versus the New India Assurance Company Limited and another reported in within bracket 2021 SAR within bracket CIV1 has held that strict principles of evidence and standards of proof like in a criminal trial are inapplicable in MACT claim cases. The standard of proof in such like matters is one of preponderance of probabilities rather than beyond reasonable doubt. One needs to be mindful that the approach and role of courts while examining evidence in accident claim cases ought not to be to find fault with non-examination of some best eyewitnesses as may happen in a criminal trial, but instead should be only to analyze the material placed on record by the parties to ascertain whether the claimant's version is more likely than not true. So in this case, the intent of the learned tribunal to find out the default in the evidence of PW1 appears to me not justified. Stop. Thank you.